Many people think that trusts are only for wealthy people, but that's actually not true. If you have any assets of any significant value, which in California you can think of is around $185,000 or so, then you should strongly consider getting a trust. And this is in order to accomplish a number of things. One is to avoid the probate process, which in California is a very expensive and time-consuming process that you can avoid by having a trust in place. And you can accomplish some other things, such as protecting your assets from creditors, ensuring that your assets go exactly the way you want it to go, to whom you want it to go, and to keep your financial matters private. If you're curious to learn more about what actually a trust is for and how to get one in place, stick around because we are going to dive into exactly what a trust is, different terminology associated with trusts, and steps to get one in place. Hi, I'm Cindy Kang. I am the founder of CMK Law Group. I am an estate planning and small business lawyer, and I support families accomplish their peace of mind through comprehensive estate planning, and I support entrepreneurs with their small business legal needs. So, what is a trust? A trust is a legal arrangement where one party, which we call the trust maker, or they're also called the trustor or the grantor, there are multiple names, but we'll just say trust maker, transfers assets to another party, which is the trustee, to manage for the benefit of a third party, which is the beneficiary. And trusts can come in multiple formats, but the most common forms that you hear about are irrevocable trusts or revocable trusts. And revocable trusts, these are the trusts that are more common for the average trust-based estate plan. And these are completely amendable and revocable during the lifetime of the trust maker. And they offer flexibility and control and all of the benefits that we briefly discussed. We'll go into it in a little bit more detail. An irrevocable trust, once established, generally cannot have its terms altered. It's irrevocable. There are ways you can address that in certain circumstances, but the fact that they are irrevocable and non-changeable gives this type of trust very strong asset protection and tax strategy benefits. So let's talk about some benefits of a trust. There are multiple benefits, but we'll talk about the top four. The one is, as we discussed, avoiding probate. Kind of the biggest, most clear benefit is if you don't have a trust in place and you pass away, then you will most likely need to go through probate in order for the court to determine who gets what of your stuff at that time. And that is a very costly, time-consuming, and just tedious process, and very painful for your loved ones to go through after they're already sad from losing you. So avoiding probate is a primary reason of having a trust in place. Another reason is to control who gets what. So you want to, well, I would assume you want to, as most people want to, decide who should get their stuff. I mean, this is stuff that you worked your whole life to obtain and build, and you can decide who gets what, when, where, and how, and all of that is spelled out in the terms of your customized trust document. Another reason and benefit to get a trust is privacy. We mentioned briefly with the probate process, things become public record when you go through probate, which means that people who you don't know, it's like open to the public, can have access to very personal information about you, your family, your life, your estate, what you owned, how much you owned, and who gets what. So there are multiple reasons why that is problematic for many people. And the last reason is asset protection. Depending on what you have and what circumstances might be around your assets and potential creditors and lawsuits, things like that, trust can protect these assets from legal claims. And that can be a very powerful and compelling reason why certain people might want to get a trust. So let's shift over into discussing the steps to getting a trust in place. And we're going to break it down into 7 steps and go through them relatively quickly. So step 1 is determine your needs. You're going to have to figure out what are your financial goals, like what do you actually own, who are the people in your life that you'd like to leave assets to. These are the people called your beneficiaries. beneficiaries? Do you have to consider asset protection? Do you have minor children that you're concerned about that you want to make sure are taken care of? Do you have family members who have special needs where there are a host of reasons why you need to plan ahead to ensure that those loved ones are really looked after properly in the event of your incapacity or your passing? So step 2 is choosing the type of trust that's appropriate for you at the time. And this will be based on your needs, based on what the tax laws are at the time, the value of your estate is, and figuring out whether a revocable or irrevocable trust is most appropriate. And for most people, they start off with a revocable living trust as their foundational estate planning document, and then they can build on top of that with different layers of more complex trust. So step 2. Step 3 is you select your trustee. You need to find somebody very trustworthy and competent, basically capable of actually administering your wishes that you wrote out in your trust documents. Remember, trust is basically a piece of paper that has words on it that describes what your desires and your intentions are. And ultimately, the individual or entity that is going to ensure that your wishes are fulfilled will be this successor trustee. So during your lifetime, you are the initial trustee. Once you pass away, or if you become incapacitated and you're no longer able to manage your own affairs, this is when your successor trustee steps in and takes care and manages your trust assets for the beneficiaries. So you need to make sure that you pick the right person or the right company, depending on if you decide to go with the professional or personal trustee. So step 4 is identifying your beneficiaries. You have to clearly identify who in your life will benefit from your trust. And this can often include family members, your children, your surviving spouse, your friends, and charitable organizations and other organizations. And step 5 is having your trust documents prepared properly. This is where you would want to hire a competent estate planning attorney to work with you to draft a document that truly reflects your circumstances, your particular goals, and make sure that the words reflect your intent. And then after that, step 6 is you sign and notarize the trust documents. Depending on the state that you're in, there are different signing formalities. Some documents need to be notarized, some need to be witnessed, some you need to figure out work with your attorney who will know what the correct formalities are and get those signed so that they are legally valid documents. And then step 7, which is the last step, is transferring the assets into the name of the trust. So a lot of people, they think that they can check off the box. I've gotten my trust done. I'm good. And they then put their binder with their trust documents on their shelf. And they're like, oh, thank goodness that's done. But the reality is that the document means nothing unless you fund it. And that basically just means you're transferring the title, the ownership of your property, your assets into the name of the trust, because that's the only way that the trust document will be able to govern how those assets are distributed. So you do not want an empty trust because that's a useless piece of paper, basically. After you have your trust established, then there's the ongoing management of your trust. So estate planning is not really a one and done type of affair. It's not just like, okay, that's done. Not going to think about it for 40 years, because the trust is only as good as how it accurately reflects what is happening in your life. So if you have 5 new properties that you bought and they're not put into the name of the trust as, an example, then that trust doc is not really doing its job. So this is something where having a good relationship with your estate planning attorney, who ideally doesn't charge you, an hourly fee based on every time you want a question, but rather has a flat fee or whatever arrangement so that you can comfortably go back every few years and just check in and say, hey, you know what? I have this, and this update, and they'll update your trust doc so that it is a living document that reflects what is happening in your life, so that it's very effective. And it's not something that should be very time consuming. It's just, hey, you know what? Let's just update this document so that it reflects these changes, this birth of a new child or or the other event that would be needed to be reflected in that document. And then there are also costs and considerations when you're setting up a trust. There are legal fees, administrative expenses, but I think it's important to think about the long run and not be kind of penny wise, pound foolish. Oh, I don't want to spend X amount of money on setting up a trust. I'm just going to put it off, not realizing that if you unexpectedly pass and you don't have a proper trust in place, that could cost you 10, 20, 100 times more than what it would cost you to set up a trust in the first place. So it is imperative that you run that analysis. So at least based on kind of facts, whether or not it makes sense for you to create a trust. And most of the time it does. There's also taxes to consider. So trusts have specific tax implications and considerations, such as estate taxes, income taxes, capital gains taxes. All this might sound like, foreign languages to you. And you're like, I don't want to think about this. But this is what an estate planning attorney will be able to discuss with you based on your situation. Like, okay, how do you even have to worry about estate taxes? What are the income tax considerations based on the types of assets you own? And capital gains taxes, is there a step up you need to worry about in terms of when you buy something and sell something? Are you going to have a huge amount, or is your family member who inherits your property going to have a huge amount of taxes to pay if they sell the property they inherited, or versus, if you sold it during your lifetime? There are major differences depending on how you structure, how you own things, and when it's sold and how it's transferred. That can mean thousands, if not tens of hundreds of thousands of dollars in savings if you just do a little bit of pre-planning. So it's worth it. So all of these things, it's crucial to consult an experienced estate planning attorney, tax professionals. Having a team in place is worth it. Can really make a huge difference in your financial future and the legacy you leave behind to your loved ones. So in conclusion, setting up a trust is a very powerful tool for estate planning. They offer numerous benefits, and they avoid probate and sets you up for potential asset protection and privacy. At CMK Law Group, we specialize in helping individuals and families create customized trust-based estate plans to make sure that they can really have peace of mind and know that they are properly protected. If you have any questions or need assistance setting up a trust, you can feel free to contact us through the link in the description box below. And if you liked this video and hopefully learned just a little bit, please consider subscribing and liking this video, and we will see you next time. Bye.